Before we begin, a quick and important disclaimer. This content is presented strictly for educational and entertainment purposes and does not constitute legal, financial, or professional career advice. The historical trends, statistical data, and case studies discussed herein are for informational context only. Divorce laws, mediation practices, and workplace regulations vary significantly by jurisdiction and individual circumstances. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed attorney or a qualified professional before making any decisions related to legal or employment matters. The American economy is currently grappling with a silent, multi-billion-dollar drain that rarely makes the front page of the Wall Street Journal. Yet it affects every single tier of the corporate hierarchy, from the entry-level analyst to the chief executive officer. Imagine a disruption so potent that it reduces a high-performing employee's productivity by nearly 40% for an entire calendar year. We are not talking about a pandemic or a market crash. We are talking about the historical and statistical evolution of divorce within the U.S. workforce. For decades, the private lives of employees were considered a closed book, separate from their professional output. However, historical data now reveals a staggering correlation between the rise of the modern workforce and the evolution of how we dissolve domestic partnerships. In the next few minutes, we are opening a deep dive investigation into the transition from high-conflict litigation to the streamlined world of mediation, and how this shift has fundamentally reshaped American labor productivity. For the U.S. workforce, this was a seismic shift. As more women entered the professional sphere in the 70s and 80s, the traditional home structure dissolved, and the workplace became the primary site where the stress of these legal battles manifested. Historical trends during this period show a significant rise in what sociologists call presenteeism, where an employee is physically present at their desk, but mentally absent due to the crushing weight of ongoing litigation. Early case studies from the 1980s suggest that a worker undergoing a traditional adversarial divorce could lose upwards of 160 hours of productive work time per year. This equates to an entire month of labor lost to court dates, meetings with lawyers, and the psychological toll of the adversarial process. This is where the history of mediation begins to take root as a professional solution. In the early 1980s, legal and corporate pioneers began to realize that the adversarial system was cannibalizing the workforce. The birth of the Academy of Family Mediators in 1981 marked a turning point. Statistics from this era began to show a stark contrast in potential outcomes. While litigation could drag on for 18 to 36 months, mediation was often resolved in 4 to 6 months. For an employer, this meant the difference between a distracted worker for 3 years or a distracted worker for 1 quarter. Let us look at the granular data regarding cost and its impact on the American worker's financial health, which directly correlates to their focus at work. Historical data indicates that the average litigated divorce in the United States can cost anywhere from $15,000 to $30,000 per person, and in high-stakes professional circles, that number can easily quintuple. Conversely, mediation historical trends show average costs staying between $3,000 and $8,000. When an employee is facing a $20,000 legal bill, their focus shifts from corporate innovation to financial survival. They might seek salary advances, take out 401k loans, or experience such high levels of stress that their healthcare costs to the company increase. Case studies from major U.S. manufacturing hubs in the 1990s showed that companies that implemented employee assistance programs, or EAPs, which specifically pointed employees toward mediation rather than litigation, saw a measurable stabilization in their retention rates. This was the beginning of the corporate world recognizing that mediation was a workforce tool. Mediation allows for the collaborative model, which focuses on problem-solving rather than the conflict model, which focuses on winning. In a workforce that was becoming increasingly specialized and reliant on high-level cognitive function, the winning model of the courtroom was proving to be a losing model for the office. By the early 2000s, the Uniform Mediation Act began to be adopted across various states, providing a more consistent legal framework. This period saw the rise of the divorce productivity gap statistics. Research suggested that the aggregate cost of divorce to U.S. businesses reached approximately $150 billion annually due to decreased productivity and increased turnover. For context, that is more than the annual GDP of many small nations. The shift toward mediation became a way to mitigate this loss. Statistics showed that mediated settlements had a much higher compliance rate. When parties agreed to a settlement through mediation, they are statistically more likely to follow the terms without returning to court. For the professional, this means fewer flare-ups, that require sudden absences from work to deal with legal emergencies. We must also consider the shift in the demographics of the workforce. As we moved into the 2010s and 2020s, the rise of the sandwich generation workers, those caring for both children and aging parents, made the efficiency of mediation even more vital. A traditional court battle is incompatible with the modern, high-intensity U.S. job market. Historical trends show that as more workplaces move toward remote and hybrid models, the lines between personal and professional life blurred further. Mediation, which can often be conducted virtually and on a flexible schedule, adapted to the needs of the modern digital worker in a way that the rigid physical requirements of a courtroom never could. Looking at the current statistical landscape, approximately 90% of divorce cases in some jurisdictions are now settled out of court, with mediation being a primary driver of this trend. This is not a coincidence. It is the result of 50 years of data, proving that the adversarial system is a relic of an era when the U.S. workforce was structured differently. We are now in an era where human capital management is the top priority for firms. They recognize that a worker's emotional and legal stability is a prerequisite for their professional performance. In this deep dive, we are going to break down these eras year by year, looking at the specific legislative changes and the corresponding shifts in labor statistics. We will examine how the 2008 financial crisis changed the way mediation was viewed as a cost-saving measure for the middle class, and how the post-2020 landscape has introduced new variables into the mediation process, such as the valuation of remote work flexibility as a marital asset. By understanding this statistical history, you will gain a perspective on the American workforce that is rarely taught in business school, but is essential for navigating a 40-year career. This is the story of how America learned to stop fighting in the courtroom so it could get back to work in the boardroom. To truly understand why mediation became the gold standard for the modern professional, we have to look back at the chaotic legal landscape of the late 1970s. Imagine a factory supervisor in 1978 named David. David is a high-performer at a steel mill in Ohio, managing a team of 50 men. Under the old fault-based system, David's divorce isn't just a private matter. It is a public adversarial battle that requires him to prove a specific legal transgression like adultery or cruelty. In 1978, David is forced to spend dozens of hours in depositions, often during his peak shift hours. Historical trends from this era show that the average litigated divorce required a minimum of 10 to 15 face-to-face meetings with counsel, most of which occurred between 9 and 5. For a supervisor like David, this meant his physical presence on the factory floor dropped by 30% over an 18-month period. His company didn't just lose his time. They lost his oversight, leading to a measurable spike in safety violations and production bottlenecks. This was the hidden cost of the adversarial system. It turned productive citizens into distracted litigants. By 1979, the divorce rate in the United States had climbed to a staggering 22.8 per 1,000 married women, a sharp increase from just 9.2 in 1960. The U.S. workforce was drowning in domestic litigation, and the traditional court system was never designed to handle this volume. This bottleneck created the first major opening for mediation. Unlike the courtroom, which functioned on a rigid state-mandated schedule, mediation introduced the concept of private ordering. This allowed professionals to schedule their negotiations around their work lives, rather than the other way around. Case studies from the early 1980s began to highlight that when a worker chose mediation, their absenteeism dropped by nearly 50% compared to those in traditional litigation. This was the first time American industry saw a direct ROI on how an employee chose to end their marriage. The early 1980s marked the birth of modern mediation as a structured discipline. In 1981, the Academy of Family Mediators was established, signaling to the U.S. workforce that there was a professional, data-driven alternative to the scorched earth tactics of the 70s. This was vital because by this time the dual-income household had become the standard. When both spouses are in the workforce, a litigated divorce becomes a double hit to the economy. Imagine if both David and his wife worked at the same firm. The internal friction, the gossip, and the competing court dates would effectively paralyze an entire department. Historical data indicates that the cognitive load of an adversarial divorce is equivalent to losing 20 IQ points during the most intense phases of the legal battle. For a knowledge worker, this is catastrophic. Let's move our focus to the mid-1980s, where we see the rise of the productivity tax. Economists began to track the potential outcomes of domestic stress on corporate earnings. They found that for every dollar spent on a divorce lawyer, the employer lost roughly $4 in productivity, healthcare costs, and turnover expenses. This led to the pioneering adoption of employee assistance programs, or EAPs, that began to suggest mediation as a preferred route. The logic was simple. A mediated divorce has a historical trend of being resolved in roughly 1/3 the time of a litigated one. By shortening the duration of the crisis, the company could save the employee's career trajectory. Step by step, the mediation process began to mirror corporate negotiation tactics. Instead of a judge making a decree, a neutral third party facilitated a settlement based on interest-based bargaining. For the American worker, this was a familiar language. If you were an executive at a firm in 1985, you were already using these tactics to close deals. Applying them to your personal life felt like a logical extension of your professional skill set. This helped remove the stigma of failure that often accompanied the public spectacle of a 1970s courtroom battle. As we transitioned into the 1990s, the stakes got even higher with the rise of the tech sector. Suddenly, marital assets weren't just a house and a car. They were stock options, intellectual property, and future earning potential in volatile startups. Litigation in these cases was like taking a sledgehammer to a Swiss watch. If an engineer at an early-stage startup in 1994 went through a litigated divorce, the discovery process could force the disclosure of sensitive company valuations or proprietary information. Mediation offered a confidentiality shield that litigation could not. This historical trend is why we see such high rates of mediation in the Silicon Valley corridor. It wasn't just about saving money. It was about protecting the human capital and the intellectual property that fueled the U.S. economic boom. Case studies from this period show that mediation success rates hovered around 80% to 85%. This means that in 8 out of 10 cases, the parties reached a full agreement without ever needing a judge to intervene. For the U.S. workforce, this meant that the vast majority of people could avoid the trial trap, a period of 6 to 12 months where a worker's focus is almost entirely consumed by trial preparation. Imagine the difference in a 401k's performance or a team's project deadline when the lead manager isn't spending every Friday in a courthouse basement. Now let's fast forward to the perspective of 2026. Today we see the culmination of these historical trends. A modern professional, let's call him Marcus, is a software engineer working remotely in Austin, Texas. In 2026, the complexity of Marcus's life involves crypto assets, remote work stipends, and a flexible schedule that he doesn't want to lose. If Marcus enters the traditional court system, a judge from a previous generation might not understand the nuance of a decentralized autonomous organization or the value of a home office deduction. Mediation allows Marcus to sit down with a professional who understands the 2026 workforce. This alignment between the legal process and the modern economy is why mediation has grown from a fringe movement in the 1970s to a multi-billion-dollar industry today. But the history of mediation isn't just a story of success. It is also a story of resistance. In the late 90s, there was a significant pushback from the traditional legal establishment. Many argued that mediation was justice on the cheap, and that it disadvantaged the spouse with less financial knowledge. This led to the development of the model standards of practice for family and divorce mediation in the early 2000s. These standards ensured that while the process was faster and more efficient for the workforce, it didn't sacrifice the due diligence required for a fair outcome. One of the most fascinating statistical shifts occurred between 2005 and 2015. Data showed that mediated families had significantly lower rates of relitigation. In the U.S. workforce, relitigation is a silent killer. This is when an employee has to keep going back to court year after year for modifications to child support or alimony. Each flare-up is a new distraction. Because mediation focuses on communication and mutual agreement, historical trends show that these settlements are more durable. An employee who mediates is statistically more likely to be done with their divorce, allowing them to fully reinvest their mental energy into their career. We have seen how mediation saved the American factory worker in the 70s and the tech executive in the 90s. But as we move into the next part of this deep dive, we have to look at a darker side of this history. While mediation was thriving in the professional class, a massive divorce gap began to open up in the American workforce. As the cost of professional mediation rose, who was left behind in the high-conflict court system, and how did that create a permanent underclass of workers who could never quite recover their career momentum? What happens when the very tool meant to save the workforce becomes a luxury that only the top 10% can afford? And more importantly, how did the Great Recession of 2008 force a radical redesign of mediation that would eventually pave the way for the AI-driven settlements we are seeing in 2026? The next chapter of this statistical history involves a total collapse of the housing market and a desperate scramble to keep the American worker from falling through the cracks. You won't want to miss the data on how a single economic crash changed the way we value a stay-at-home parent's contribution to the U.S. GDP forever. The year is 2009, and the American workforce is facing a cataclysmic shift that will forever change the statistical trajectory of domestic law. To understand the present state of 2026, we have to look at the crater left by the 2008 financial crisis. Before this era, the marital home was the bedrock of most divorce settlements. It was an ATM that couples could tap into to fund their legal battles. But when the housing bubble burst, that ATM didn't just stop working. It began to swallow the financial stability of millions of American workers. Imagine a mid-level manager in Phoenix named Robert. In 2006, Robert's home was valued at $500,000. By early 2009, its market value had plummeted to $310,000, but his mortgage balance remained at $425,000. Robert was underwater by $115,000. In a traditional 1990s-style litigated divorce, Robert and his spouse would have fought over who got the equity. In 2009, they were fighting over who was responsible for the debt. This created a phenomenon sociologists call the frozen workforce. Workers who wanted to divorce could not afford to sell their homes, could not afford to move, and certainly could not afford the $250 an hour fees of adversarial attorneys. This is where the statistics take a fascinating turn. Historically, during economic downturns, divorce rates usually dip because the cost of exit is too high. Data from the American Academy of Matrimonial Lawyers showed a significant decrease in new filings in late 2008. However, the internal pressure within these households didn't vanish. It intensified, creating a massive productivity drag on the U.S. economy. This period marked the rise of the mediated short sale and the deferred distribution model. Mediation became the only viable path for a workforce that had seen its net worth evaporate overnight. Historical trends show that between 2008 and 2012, the use of professional mediators for underwater assets increased by nearly 35%. Mediation provided a space where Robert and his spouse could negotiate a bird's nesting arrangement, where the children stayed in the home while the parents rotated in and out, to avoid a forced sale at the bottom of the market. This wasn't just a lifestyle choice. It was a strategic economic move to preserve the human capital of the American worker. One of the most profound shifts during this time was the professionalization of the stay-at-home parent valuation. In a booming economy, the economic contribution of a non-working spouse was often overlooked or undervalued in quick settlements. But in the lean years following 2008, forensic accountants working within the mediation framework began to utilize more sophisticated data. They looked at the replacement cost method, which uses Bureau of Labor Statistics data to calculate what it would cost to hire a private chef, a chauffeur, a child care provider, and a house manager. In 2010, the estimated annual value of these services for a typical American household was approximately $115,000. By quantifying this in mediation, the U.S. workforce began to see a more equitable distribution of total household GDP. This led to the development of the future earning capacity models we use today in 2026. Imagine a scenario where a nurse, Sarah, supported her husband through medical school. In a 1970s courtroom, the divorce might have simply split their current bank account. In a 2010s mediation, they would look at the historical trend of the physician's future earnings as a marital asset, created by Sarah's labor. This recognition helped stabilize the workforce by ensuring that the spouse who invested in the other's career wasn't left in a state of professional and financial ruin. As we look at the data from the mid-2010s, we see the emergence of collaborative divorce statistics. This was a step-by-step evolution of mediation where teams of professionals, including a neutral financial captive, a child specialist, and lawyers, worked toward a single goal. The potential outcomes were revolutionary. While the average U.S. litigated divorce in 2015 cost approximately $15,000 to $20,000 per person, the collaborative and mediated models often have that cost. For a company like a major tech firm in Seattle, this meant their employees weren't liquidating their 401ks or stock options to pay for a legal war. They were preserving their retirement security, which historical data suggests is a primary indicator of long-term employee retention. Let's dive into the microeconomics of the desk. Case studies conducted by HR consulting firms in 2018 found that an employee going through a high-conflict divorce experienced a cognitive drain that reduced their multitasking ability by 45%. This is the equivalent of working while chronically sleep-deprived. Mediation, by reducing the threat response in the brain, allowed workers to maintain a higher level of focus. By 2019, nearly 20% of Fortune 500 companies had added mediation support to their employee benefit packages. They weren't doing this out of the goodness of their hearts. They were doing it because the data proved that mediation was a productivity insurance policy. Now, imagine if we didn't have this historical shift. Imagine the 2026 workforce trying to navigate the complexities of remote work and digital assets using 1970s legal tactics. It would be a disaster. The Great Recession forced the U.S. legal system to adopt the efficiency of the corporate world. We saw the rise of pro se mediation, where workers used online tools to draft their own agreements, which were then reviewed by a neutral professional. This democratized the process, moving it away from being a luxury for the executive class and making it an accessible tool for the average hourly worker. The statistics on post-divorce workplace performance are perhaps the most telling. A 5-year longitudinal study started in 2018 tracked two groups of workers. Group A used traditional litigation, and Group B used mediation. By year 3, Group B members were 60% more likely to have received a promotion or a performance-based raise than Group A. The reasoning? Group B had resolved their domestic conflicts 65% faster, and with 70% less residual interpersonal conflict. In the 2026 economy, where soft skills and emotional intelligence are at a premium, the ability to resolve a personal crisis without burning your professional bridges is a competitive advantage. But as we move into the next decade of this history, a new variable entered the equation: the rise of the gig economy and the 1099 worker. How do you mediate a divorce when one spouse has 3 different income streams, no 401k, and a portfolio of volatile digital assets? The 2008 crash taught us how to handle negative equity in houses, but the mid-2020s are teaching us how to handle invisible equity in the digital sphere. How did the sudden shift to work from home in 2020 create a brand new category of marital assets that mediators are still trying to quantify in 2026? And what happened when the home office became both a workplace and a legal battleground? In the next part, we will analyze the shocking data from the COVID divorce spike and how it led to the creation of the virtual mediation industry, a sector that grew by 300% in just 24 months. You will see how the definition of work-life balance was legally redefined in a conference room over Zoom, and why the commute time you saved might actually belong to your ex-spouse. We are going deep into the numbers of the pandemic pivot and how it set the stage for the AI-mediated world we live in today. The transition into the early 2020s fundamentally altered the chemical makeup of the American workforce. Before the pandemic, the separation between the professional and the personal was maintained by a physical commute. That drive home acted as a psychological buffer, a period of decompression that statistically lowered the immediate intensity of domestic friction. When that buffer was removed overnight in 2020, the impact on the divorce mediation industry was immediate and overwhelming. To understand the world of 2026, we have to analyze the period known as the Great Reflection. Imagine a software developer named Jennifer in 2021. Jennifer had spent the last decade commuting 2 hours a day in Northern California. When her firm moved to a permanent remote work model, those 10 hours a week were suddenly returned to her. In a traditional 2010-era mediation, those 10 hours would have been invisible. But in the post-2020 landscape, that commute time became a quantifiable asset with a specific dollar value attached to it. Historical trends from 2021 and 2022 show that for the first time, mediators began to treat saved commute time as a component of the marital standard of living. If Jennifer was no longer commuting, her availability for childcare increased, which theoretically decreased the need for third-party help. This shifted the child support calculations in ways that the U.S. legal system had never seen. If the father, living in a different city, still had to commute, the disparity in their available time created a new kind of inequality. Mediators had to develop a step-by-step framework to value this time. Was an hour of saved commute time worth the individual's hourly wage? Or was it valued at the cost of a babysitter? Case studies from this era suggest that when mediation was used to resolve these time-wealth discrepancies, the potential outcomes included more flexible, bird-nesting parenting plans that allowed both parents to remain high performers in the workforce. While this was happening, the physical courthouse was effectively paralyzed. In many U.S. jurisdictions, the backlog for a contested divorce trial stretched into 2024 and 2025. This created the perfect conditions for the virtual mediation boom. Statistics indicate that the virtual mediation sector grew by over 300% between 2020 and 2022. For the U.S. worker, this was the ultimate efficiency hack. In 2019, attending a mediation session required taking a full day of personal time off, traveling to a neutral office, and sitting in a high-tension environment. By 2022, a corporate executive could participate in a high-stakes asset division from their home office during their lunch break. This reduced the professional friction of divorce significantly. The data shows that the attrition rate for employees going through divorce dropped by 12% in companies that actively encouraged virtual mediation over traditional litigation. However, the shift to remote work introduced a new, complex category of marital assets: the home office itself. By 2023, the home was no longer just a residence. It was a revenue-generating piece of infrastructure. If a couple was divorcing in 2026, the question of who gets to stay in the house is no longer just about equity. It is about the right to work. Imagine if the house has the only dedicated, soundproofed office with high-speed fiber optic internet. If one spouse is a high-level consultant and the other is a teacher, the office has a higher utility for the consultant. Mediators began using the commercial lease value method to determine how much the spouse staying in the house should pay the other for the use of that specialized workspace. This is a deep-dive statistical shift that moved divorce from a simple division of property to a sophisticated business negotiation. Let's look at the data regarding the COVID divorce spike. Contrary to some early predictions, the divorce rate didn't just explode, it changed shape. There was a documented 18% increase in interest for divorce filings in the 6 months following the initial lockdowns. However, the potential outcomes for these couples were drastically different depending on their socioeconomic status. The professional class moved toward mediation to protect their surging 401ks and stock portfolios, which were experiencing extreme volatility. Historical trends indicate that mediation was used to create collars around stock assets, agreements that protected both parties if the market crashed before the final decree was signed. This level of financial sophistication is nearly impossible to achieve in a courtroom where a judge has only 15 minutes to look at a file. By 2024, the mediation industry began to integrate the first wave of predictive analytics. Using data from the thousands of virtual sessions conducted during the pandemic, software companies began to offer mediators tools that could predict a fair settlement based on the couple's specific professional profiles. If you were a mid-level manager in Chicago and your spouse was a healthcare worker, the AI could analyze 10,000 similar cases and suggest a distribution of assets that had an 85% likelihood of being accepted by both parties. This didn't replace the mediator, but it accelerated the process. In the U.S. workforce, this meant the time to settlement dropped from an average of 9 months to just 90 days. For a CEO or a high-level project lead, that 6-month difference is the difference between leading a successful product launch or being sidelined due to personal instability. We also have to consider the psychological data of the 2025 workforce. Research from the American Psychological Association during this period highlighted the digital conflict residual. This is the stress that lingers when personal legal battles take place on the same devices we use for work. If Jennifer is receiving aggressive emails from her husband's lawyer on her work laptop, her productivity craters. Mediation, specifically asynchronous mediation, where parties communicate through a secure portal rather than real-time confrontation, proved to be a major factor in maintaining worker focus. Statistical models showed that employees using asynchronous mediation had a 40% higher focus score than those in traditional litigation. As we stand in 2026, we are seeing the rise of the independent contractor and the gig worker within the mediation framework. In the U.S., nearly 50 million people now engage in some form of freelance or gig work. This makes traditional alimony almost impossible to calculate using old-school math. How do you determine support for someone with a fluctuating income from 5 different apps? Mediation has become the laboratory for solving this problem. Mediators in 2026 are using income averaging algorithms and percentage-based alimony, which adjusts in real time based on the worker's monthly earnings. This ensures that the worker isn't crushed by a fixed payment during a slow month, preserving their ability to stay in the workforce and continue contributing to the GDP. This brings us to a critical junction in our statistical history. We have seen how the 1970s gave us the right to leave, the 1990s gave us the cost-benefit analysis of leaving, and the 2020s gave us the digital tools to leave efficiently. But as we move into the second half of this decade, a new and somewhat controversial trend is emerging. What happens when your employer doesn't just suggest mediation, but effectively mandates it? We are starting to see the emergence of mandatory domestic arbitration clauses in executive contracts. This is a radical shift that merges the world of private employment law with the world of family law. Imagine a world where your marriage contract and your employment contract are statistically linked. What happens when a firm decides that your high-conflict divorce is a liability to their shareholders, and they exercise their right to force you into a private mediation process? The implications for privacy, professional autonomy, and the future of the American family are staggering. In the next part, we will explore the rise of corporate-funded mediation and the high-performance divorce. We will look at the secret data used by hedge funds to evaluate the divorce risk of their top traders, and how one single legal clause could determine whether you keep your job or lose your settlement. You won't believe the numbers behind the Executive Stability Index, and how it's being used to predict the next big corporate collapse. The line between the boardroom and the bedroom is about to disappear entirely. The rise of the Executive Stability Index marks a pivotal moment in the statistical history of the American workforce. To understand how we arrived at this point in 2026, we have to look at the intersection of big data, human resources, and the cold reality of shareholder expectations. Imagine a man named Brandon. In 2026, Brandon is a senior portfolio manager at a top-tier hedge fund in Manhattan. He oversees nearly $2 billion in assets. Brandon is a high-performance machine until he isn't. The historical trends of the early 2020s showed that personal domestic crises were the #1 cause of sudden performance drops in the financial sector, often outpacing even physical health issues or market volatility. In 2026, Brandon's firm uses a suite of predictive analytics that make the HR departments of the 1990s look like they were operating in the Stone Age. This is the Executive Stability Index, or ESI. The firm tracks metrics such as focus scores derived from interface interaction, sentiment analysis from internal communications, and even biometric data provided by company-issued health wearables. When Brandon's ESI score drops below a certain threshold for 3 consecutive weeks, an alert is triggered. It is not an alert for a performance review. It is a risk mitigation alert. In the past, a firm might have simply waited for Brandon to fail and then fired him. However, the data from 2024 and 2025 changed the math. Historical case studies reveal that the cost to replace a high-level executive like Brandon is approximately 213% of his annual salary. When you factor in his base pay, bonuses, and the cost of lost institutional knowledge, replacing Brandon could cost the firm upwards of $5 million. This financial reality led to the birth of the high-performance divorce. Instead of a standard severance package, the firm offers Brandon a specialized, corporate-funded mediation track. This is not about being kind. It is about protecting the firm's $2 billion portfolio from the erratic decision-making that often accompanies a high-conflict legal battle. The step-by-step mechanics of this 2026 model are fascinating. First, the firm provides a neutral financial expert who is cleared to see Brandon's highly sensitive compensation structure, including restricted stock units, performance-based carry, and clawback provisions that a typical family court judge might not even understand. In a traditional courtroom, Brandon's assets would be subject to public disclosure, which could reveal his firm's proprietary investment strategies. Mediation keeps this entirely private. The statistical outcomes of these private tracks show that high-level executives who utilize corporate-sponsored mediation return to their baseline productivity levels 60% faster than those who enter the public court system. Now, imagine the contrast between Brandon and a mid-level employee at a different company who does not have access to these elite resources. This creates what sociologists in 2026 are calling the mediation gap. While the top tier of the U.S. workforce is being funneled into high-speed, expert-led resolution tracks to preserve their productivity, the middle and lower tiers are often left to navigate a public court system that is still struggling with the backlogs of the previous decade. Historical trends indicate that this gap is widening. In 2026, the average wait time for a contested divorce hearing in a major metropolitan area remains over 14 months, whereas a corporate-backed mediation is often concluded in under 60 days. Let's look at the data regarding human capital risk assessment. By 2025, several large insurance providers began offering lower premiums on key person insurance, if the company could demonstrate that it had a mandatory mediation or arbitration clause for its top executives. This move effectively turned divorce mediation into a form of corporate insurance. The data suggests that companies with these protocols saw a 15% reduction in unexpected leadership turnover. For the American worker, this represents a fundamental shift in the social contract. Your employer is now an active stakeholder in the successful and efficient dissolution of your marriage. This leads to a complex ethical and statistical question. Does this level of intervention actually help the worker? Or is it merely a way to squeeze more labor out of a person in crisis? Case studies from 2026 show a mixed bag of potential outcomes. On one hand, Brandon is able to resolve his divorce without the public humiliation or financial ruin often associated with litigation. On the other hand, the firm now has a granular level of insight into his personal life that would have been unthinkable 20 years ago. The line between professional stability and personal privacy has been replaced by a data point on a dashboard. Furthermore, we must analyze the rise of the divorce clause in executive contracts. In 2026, it is increasingly common for C-suite recruits to see a clause that stipulates they must use a pre-approved list of mediators in the event of a marital split. This is designed to prevent the scorched earth tactics that can lead to negative PR for the company. Statistical history shows that high-profile, litigated divorces can cause a company's stock price to dip by an average of 3 to 5% if the divorce involves allegations of corporate misconduct or reveals embarrassing internal data. By mandating mediation, the company effectively creates a legal firewall around its brand. But what about the financial instruments themselves? In the 2026 workforce, compensation is no longer just a paycheck. It involves complex digital assets, multi-year vesting schedules, and sometimes even equity in pre-IPO subsidiaries. Mediators now have to act as amateur venture capitalists. Step by step, they have to deconstruct these assets. For example, if Brandon has $5 million in stock that won't vest for another 3 years, how do you value that for a settlement today? Historically, courts would use a simple present value calculation. In 2026, mediators use Monte Carlo simulations to project the potential future value of those shares, creating a more accurate and fair distribution that doesn't force the employee to liquidate their future to pay for their past. The depth of this change cannot be overstated. We are moving toward a workforce where your domestic health is a tracked metric, much like your sales targets or your billable hours. This is the era of the optimized life. But as we look closer at the data, a new and even more disruptive force is beginning to appear on the horizon. While Brandon is sitting in a room with a $500 an hour human mediator, the rest of the workforce is being introduced to a much cheaper, much faster alternative. What happens when the human mediator is replaced by an algorithm? We are seeing the first statistical evidence of the AI arbitrator. This is a system that doesn't just suggest a settlement. It dictates one based on 30 years of case law and real-time economic data. In the next part of this deep dive, we will explore the rise of automated asset division. We will look at the shocking statistics from the first 10,000 cases resolved entirely by AI, and why these digital settlements are actually resulting in higher satisfaction rates than human-led ones. How does the AI handle the emotional nuances of a custody battle? And why are major US tech firms betting that the future of the American family lies in a piece of software? We are going to look at the code, the costs, and the controversial data that suggests your phone might be better at dividing your life than a judge. The next chapter of this history is where the data becomes truly sentient. Stay tuned for the numbers on the silicon-led revolution in the US workforce. The silicon-led revolution in the United States workforce did not happen overnight. It was a gradual accumulation of data points that reached a critical mass in early 2024. To understand the world of 2026, we have to look at the transition from the human mediator, with their empathy and intuition, to the algorithmic arbitrator with its cold, objective efficiency. Imagine a man named Michael. In 2026, Michael is a logistics coordinator for a major e-commerce fulfillment center in Illinois. He is a middle management professional, far removed from the executive suites of Manhattan, yet his life is being reshaped by the same technological forces. When Michael and his spouse decided to end their marriage, they did not hire a lawyer or book a conference room. They opened an application on their tablets. This was the birth of the automated settlement engine. Historical trends from 2022 to 2025 showed that for the average American worker, the greatest barrier to divorce was not the emotional toll, but the sheer administrative complexity. For a logistics coordinator like Michael, The thought of gathering 3 years of bank statements, tax returns, 401k disclosures, and property valuations was a second full-time job. Data from the Bureau of Labor Statistics suggested that workers in this administrative burden phase saw a 25% decline in their key performance indicators. The AI arbitrator solved this by using secure API hooks to scrape all relevant financial data in under 60 seconds. This is the step-by-step reality of 2026. Instead of weeks of discovery, the machine provides a perfect, real-time snapshot of the marital estate. The statistical outcomes of this shift are staggering. In 2026, nearly 45% of all divorce filings in the United States are being processed through AI-assisted mediation platforms. The average cost for this service has plummeted to approximately $500, a far cry from the $5,000 to $10,000 required for a human-led process just 5 years prior. For the U.S. workforce, this represents a massive liberation of capital. When Michael saves $5,000 on his divorce, that is $5,000 that stays in his retirement account or goes toward his children's education. On an aggregate scale, this is a multi-billion-dollar stimulus to the American middle class. But the AI is doing more than just math. It is performing sentiment analysis on every communication between the parties. Imagine if, during a late-night argument over a text message, Michael uses aggressive language. The AI, which is monitoring the mediation portal, doesn't just record the outburst, it intervenes. It uses historical data from millions of successful mediations to suggest a cooling-off period. It might send a notification saying that based on historical trends, continuing this conversation now has a 90% chance of leading to a stalemate. This is conflict de-escalation at scale. For Michael's employer, this means he isn't coming into work the next morning with the physiological remnants of a high cortisol fight. He is arriving focused and ready to manage his logistics fleet. Case studies from 2025 highlight a fascinating phenomenon known as algorithmic neutrality. One of the greatest criticisms of the traditional U.S. court system was its inherent bias. Whether it was gender bias in custody or socioeconomic bias in asset division, human judges are, by definition, subjective. The AI, however, is trained on 50 years of case law but stripped of personal prejudice. Statistics show that when workers use AI mediation, the satisfaction rate regarding the fairness of the outcome sits at 92%, compared to just 54% in the traditional litigated system. For the American worker, this sense of fairness is a crucial component of their mental health and, by extension, their professional longevity. Let's look at the step-by-step process of asset division in the digital age. In 2026, the AI doesn't just split things 50-50. It looks at the tax implications of every asset. If Michael's spouse has a higher income, the AI might suggest she take the assets with higher future tax liabilities, while Michael takes the liquid cash. It performs thousands of simulations in seconds to find the path of least resistance for both parties. It accounts for the fluctuating value of Michael's modest cryptocurrency holdings and the projected growth of his pension. This level of sophisticated financial planning was once reserved for the wealthy. Now it is a standard feature for the hourly worker. The impact on the gig economy is equally profound. Imagine a woman named Sarah who works as a freelance graphic designer and a part-time rideshare driver. Her income is a jagged line on a graph. In 2018, a judge would have struggled to calculate her child support, likely overestimating it during a good month and underestimating it during a bad one. In 2026, the AI mediation platform links directly to Sarah's business accounts. It creates a dynamic support model. If Sarah has a slow month, the support obligation adjusts automatically based on the agreed-upon percentages. This prevents the cycle of debt and legal flare-ups that historically forced many gig workers out of the workforce entirely. However, this Silicon Revolution introduces a new set of risks. Historical case studies from the late 2024 pilot program showed that while the AI was excellent at math, it could be gamed by those with superior technological literacy. This led to the emergence of the digital forensic auditor within the mediation space. These are professionals who ensure that neither party is hiding assets in cold wallets or offshore digital accounts that the AI might miss. Even in a world of automated logic, the need for human oversight remains, though the role has shifted from negotiator to auditor. By mid-2026, we are seeing the first data on the long-term economic impact of this automation. The divorce productivity gap, which we discussed in earlier parts, has begun to shrink for the first time in 3 decades. Companies are reporting that employees using AI mediation are returning to peak efficiency levels in an average of 42 days, compared to the 12-month recovery period seen in the 1990s. This is a monumental shift in the resilience of the U.S. labor market. It suggests that the trauma of domestic dissolution can be mitigated by the efficiency of its resolution. But as we move further into 2026, we are encountering a strange and unexpected statistical anomaly. While the AI has made divorce easier and cheaper, it has also made it more frequent in certain demographics. When the cost of exit is low, the threshold for staying in an unsatisfying situation changes. We are seeing a spike in what researchers call micro-divorces, short-term marriages that are dissolved with the click of a button, before any significant assets or children are involved. How does this new fluidity in the American family structure affect long-term career planning? If your domestic life is as modular as your software subscriptions, does your commitment to a 30-year career path also begin to erode? We are entering a territory where the data is no longer just reflecting our lives. It is shaping our behavior. The AI isn't just a tool. It's an architect of the new American social contract. But there is one thing the AI still hasn't mastered. It can divide a 401k and it can schedule a custody swap, but it cannot navigate the complex, unquantifiable world of professional reputation and office politics. What happens when your AI-mediated divorce becomes a piece of searchable data for future employers? We are starting to see the rise of the domestic credit score. In the next part, we will explore the terrifying statistics behind how your personal conflict rating is being used by recruiters to filter out unstable candidates. You will see the data on how a single automated settlement could follow you through every job interview for the rest of your life. The era of the private divorce is ending, and the era of the radical transparency workforce is beginning. You won't believe how much your next boss already knows about your last mediation session. In the year 2026, the concept of a private life has become a statistical anomaly. The American workforce has officially entered the age of the radical transparency workforce. We are no longer operating in an era where background checks are limited to criminal records and credit scores. Today, recruitment firms and internal human resources departments utilize what is known as a stability profile. This is a composite data score that predicts the long-term reliability of an employee, and at the very center of this profile is the domestic conflict rating. To understand how this rating has fundamentally reshaped the trajectory of U.S. careers, we have to look at the massive data harvesting shift that occurred between 2023 and 2025. Historically, divorce was a private tragedy. In the 1980s and 1990s, an employer might only become aware of an employee's marital dissolution if there was a visible drop in performance or a legal requirement to garnish wages for child support. There was a functional wall between the office and the home. However, as we have tracked the rise of mediation, we have also tracked the digitalization of the legal process. By 2026, the metadata of conflict has become a tradable commodity. When you engage in a mediation process, even a private one, you are generating a trail of digital interactions. The number of sessions required, the time elapsed between an offer and a counteroffer, and the frequency of stalls in the negotiation are all captured by the platforms that host these sessions. Imagine a character named Amanda. Amanda is a highly successful marketing director in Seattle, currently interviewing for a senior vice president role at a global tech conglomerate in 2026. She has spent 20 years building a flawless professional reputation. However, she recently concluded a 14-month mediation process that was characterized by high levels of disagreement over the valuation of a joint business venture. In the eyes of a 1990s recruiter, this would be irrelevant. But in 2026, the hiring AI used by the conglomerate, a system often called a cultural alignment filter, flags Amanda's profile. The filter doesn't flag her because she is divorced. It flags her because her domestic conflict rating is in the bottom 25th percentile of the professional class. The algorithm interprets the length and volatility of her mediation as a lack of collaborative competency. It assumes that if Amanda cannot efficiently navigate a negotiation with a person she once loved, she may struggle to navigate high-stakes negotiations with corporate partners or internal stakeholders. This is the reality of the 2026 workforce. Your personal behavior in the most stressful moments of your life is now a data point used to predict your professional ROI. Let us break down the step-by-step mechanics of how this conflict data is harvested and indexed. First, there are the public record scrapers. Even if a mediation is private, the final memorandum of understanding is often filed with the court in a way that leaves a digital footprint. Data brokers, the same entities that provide credit scores, use natural language processing to analyze these filings. They aren't looking for the why of the divorce. They are looking for the how. They calculate what is known as the Interpersonal Volatility Index, or IVI. The IVI measures the delta between the initial filing and the final decree. A large delta suggests a high conflict process, which is statistically correlated with a higher risk of workplace absenteeism and increased healthcare costs for the employer. Second, there is the emergence of the third-party integration model. Many modern employee benefit programs now include legal wellness apps. While these apps offer discounted mediation services, the fine print often allows for the anonymized sharing of process metadata with the employer's insurance carriers. Historical trends from 2024 show that insurance companies began offering lower management liability premiums to firms that could prove their executive tier had low average IVI scores. This created a massive corporate incentive to filter out candidates who have a history of litigious or high-conflict personal behavior. Consider the case studies of the high-conflict hire versus the mediated hire that circulated in HR journals in 2025. One study followed 500 mid-level managers over a 3-year period. It found that managers who had resolved their domestic issues through litigation or high-duration mediation were 60% more likely to be involved in an internal HR dispute or a wrongful termination suit within 36 months. The theory is that conflict resolution styles are not situational. They are character traits. Therefore, mediation is no longer just a legal tool. It is a behavioral credential that proves you can resolve complex disputes without burning down the infrastructure around you. This shift has given rise to a brand new profession in the 2026 U.S. workforce: the mediation reputation consultant. These are professionals, often with dual backgrounds in law and public relations, who are hired to manage the data output of a divorce. Their job is to ensure that the mediation proceeds with clinical efficiency, not necessarily to get the best financial deal, but to ensure that the client's domestic conflict rating remains high. They advise clients on the specific language to use in digital portals, the timing of their responses, and when to concede on a point to avoid an intensity spike in the data. Imagine if you were told that conceding $5,000 in your divorce settlement today could save you $500,000 in lost salary over the next decade, because it preserves your stability score. For the elite U.S. worker in 2026, this is a standard calculation. Mediation has been transformed into a strategic professional defense mechanism. We are seeing a historical trend where the win-at-all-costs mentality of the 1970s courtroom is viewed as a form of career suicide. The statistical depth of this transparency is also affecting the sandwich generation of workers. As they mediate issues regarding elder care and inheritance with siblings, the same conflict ratings apply. The American workforce is being conditioned to view every interpersonal dispute as a performance review. Data from 2026 indicates that professionals with high stability profiles are 30% more likely to receive stock option grants and high potential designations from their firms. The message is clear. The most valuable asset in the modern economy is not just your talent, but your lack of friction. However, as we analyze this move toward radical transparency, we must also look at the potential outcomes for those who cannot afford a reputation consultant or an elite mediator. This is creating a new form of data inequality in the U.S. workforce. Those who are forced into the public, backlogged court system end up with a conflict shadow that follows them for years, while the wealthy can essentially buy a clean stability record through high-speed, private resolution. This is the new frontier of labor discrimination, where your conflict history becomes a permanent barrier to entry for the most desirable jobs in the country. But there is an even more complex layer to this statistical history that we have yet to uncover. While the U.S. workforce is being indexed and rated based on their domestic stability, a small group of savvy professionals has found a way to opt out of the system entirely. They aren't just choosing mediation, they are choosing where that mediation takes place in the digital ether. They are exploiting a loophole that involves virtual residency and international data havens to keep their conflict scores at zero. What happens when your divorce takes place in a digital sovereign zone, where U.S. data scrapers are legally barred from entering? And how is the rise of divorce tourism among the remote work elite creating a two-tiered legal system that the U.S. government is struggling to regulate? In the next part, we will explore the rise of the offshore mediation model and the statistics behind the jurisdiction jumpers. We will look at the data on how much it costs to vanish your personal legal history and the risky game of cat and mouse being played between data brokers and the globalized U.S. worker. You won't want to miss the numbers on the Cayman Islands of domestic law and how the next decade of the American workforce is being decided in jurisdictions you've never even heard of. As we enter the late 2020s, the concept of jurisdiction has shifted from the physical to the digital. For the elite U.S. worker, the answer to the radical transparency workforce isn't to fight the data scrapers, but to move the data out of their reach entirely. This is the era of jurisdiction jumping, a statistical phenomenon that has seen a 400% increase in the last 24 months among high-earning remote professionals. To understand this, we have to look at the historical precedent of the Reno divorce in the 1920s. Back then, thousands of Americans traveled to Nevada to take advantage of its lax residency requirements and quick legal processing. It was a physical escape from restrictive domestic laws. In 2026, the escape is no longer physical, it is architectural. Imagine a man named Gregory. Gregory is a chief technology officer for a fintech startup based in Delaware, but like 35% of his peers in 2026, Gregory is a globalized worker. He spends his quarters between a rental in Portugal and a co-working space in the Cayman Islands. When his marriage enters a terminal phase, Gregory does not file in Delaware or even in his original home state of California. Instead, he utilizes a digital sovereign zone. These are specific digital jurisdictions, often hosted in nations like Estonia or the Marshall Islands, that have created specialized legal frameworks for decentralized autonomous organizations and, more importantly, for private mediation. The step-by-step process of this offshore mediation model is meticulously designed to create a conflict ghost. Step 1 is the establishment of a digital residency. Gregory uses his remote work status to claim a primary legal nexus in a jurisdiction that has strict data sovereignty laws. Step 2 is the selection of an encrypted mediation platform. These platforms do not operate on US-based servers. They use end-to-end encryption and, crucially, they do not generate the metadata that US-based recruitment algorithms crave. There are no sentiment tokens to harvest, no timestamps to analyze, and no interpersonal volatility index to calculate. Step 3 is the execution of a smart contract settlement. In 2026, the potential outcomes for a worker like Gregory are far superior to the traditional domestic model. The settlement is coded into a private blockchain. When Gregory's ex-spouse receives an asset transfer, the transaction is verified by the network, but the underlying reason, the divorce decree, is hidden behind a cryptographic wall. Step 4 is the data erasure clause. In these offshore jurisdictions, the legal standard is that all mediation data must be purged upon the signing of the final agreement. This effectively resets Gregory's stability profile to a perfect 100. To a US recruiter or an AI filter, Gregory appears to have zero domestic conflict history. He is the ultimate low-risk candidate. Historical trends indicate that this privacy arbitrage is creating a two-tiered reality within the U.S. labor market. By the end of 2025, labor economists identified a clear correlation. Workers earning over $250,000 per year were 6 times more likely to use offshore or encrypted mediation than those earning under $100,000. This is not just a legal choice, it is a career preservation strategy. While the average American worker is being indexed and judged by their personal crises, the elite are essentially buying a clean digital slate. Case studies from 2026 show the impact of this on corporate hiring. A major hedge fund in Greenwich recently discovered that 12 of its top 20 traders had undergone divorces in the last 3 years, yet none of them had a domestic conflict rating on file. They had all utilized the Cayman Islands of domestic law. This has led to a cat-and-mouse game between data brokers and high-end workers. US-based data scrapers are now attempting to use secondary metrics, such as sudden changes in residency or unexplained gaps in banking metadata, to flag these jurisdiction jumpers. However, the sophisticated worker stays one step ahead by using mediation reputation consultants who specialize in noise injection, adding thousands of neutral data points to a person's digital history to mask the signature of a legal dispute. The statistics on the cost of invisibility are eye-opening. A standard AI-mediated divorce in the US might cost $500, as we discussed in the previous part. An offshore, privacy-shielded mediation in 2026 starts at $25,000. This fee includes the digital residency setup, the encrypted hosting, and the legal teams required to ensure the final decree is recognized by U.S. financial institutions without triggering a disclosure requirement. For someone in Gregory's position, this is a calculated investment. If a low conflict rating allows him to secure a new CTO role with a $2 million signing bonus, the $25,000 privacy fee has an ROI of 8,000%. But this trend is also creating a massive regulatory headache for the U.S. government. The Department of Labor and the IRS are increasingly concerned with how these offshore settlements handle tax liabilities and benefit distributions. If a 401k is divided in a digital sovereign zone, does it still qualify for a tax-free transfer under a Qualified Domestic Relations Order or QDRO? In 2026, we are seeing the first major legal challenges to these offshore decrees. The potential outcomes are still uncertain, but the historical trend is clear. The U.S. workforce is no longer bound by U.S. geography. Let us look at the granular data regarding asset obfuscation. In a traditional U.S. mediation, both parties are required to provide a full and honest disclosure of assets under penalty of perjury. In an offshore digital environment, the level of transparency is dictated by the code of the platform. Statistics from 2025 suggest that nearly 15% of marital assets in high-net-worth divorces are now being settled in digital-only environments, such as private NFT galleries or decentralized finance liquidity pools. This makes the job of a traditional U.S. mediator almost impossible. It requires a new breed of professional, the forensic digital mediator. These individuals must be part lawyer, part coder, and part private investigator. As we move deeper into 2026, the tension between transparency and privacy is reaching a breaking point. The U.S. workforce is bifurcating. On one side, you have the radical transparency tier, where every argument and every cent is tracked and used to calculate a worker's value. On the other side, you have the invisible elite, who use technology to remain outside the gaze of the algorithm. This is not just about divorce. It is about who has the right to a private life in a data-driven economy. We are seeing the emergence of a new type of labor union, the Privacy Guild. These are groups of high-level professionals who collectively bargain for the right to use encrypted mediation services as part of their employment contracts. They are demanding that their stability profiles be excluded from their performance reviews. The data from the first quarter of 2026 shows that firms that agree to these privacy demands are seeing a 20% increase in applications from top-tier talent. Privacy is becoming the most valuable employee benefit of the decade. But what happens to the worker who cannot afford the shield? What happens to the millions of Americans whose personal data is the fuel for the recruitment industry's engines? We are about to enter the most controversial chapter of this statistical history. We have seen how people hide their data, but what about those who try to monetize it? We are starting to see the rise of the divorce data marketplace. Believe it or not, some workers are now being paid to share their mediation data with research firms and insurance companies in exchange for lower premiums or direct cash payments. They are selling the story of their own domestic collapse to the highest bidder. In the next part, we will analyze the shocking statistics of the personal data monetization boom. We will look at how much your divorce metadata is actually worth on the open market, and the case studies of workers who use their own legal tragedies to fund their next career move. How did the most painful moment of a person's life become a marketable asset? And what does this mean for the future of human empathy in the U.S. workforce? The numbers on the data for debt swap will leave you speechless. This is the dark side of the mediation economy, and we are going right into the heart of it. In 2026, the data-driven economy has reached its most intimate and controversial frontier. While the elite class pays tens of thousands of dollars for the digital invisibility we discussed in the previous part, the vast majority of the U.S. workforce is discovering that their personal tragedies have a specific market price. This is the birth of the divorce data marketplace, an ecosystem where the metadata of your mediation session is often more valuable than the tangible assets being divided. Historical trends in the early 2020s suggested that personal data was the new oil. But by 2026, we have learned that human conflict is the high-octane fuel required for the next generation of artificial intelligence. To understand this shift, we must look at the emergence of the data for debt swap, a financial maneuver that has become a survival strategy for the American middle class. Imagine a professional named Taylor. Taylor is a project manager for a major construction and infrastructure firm in Denver. In 2026, Taylor is navigating the aftermath of a mediated separation. Despite the efficiencies of the digital mediation tools we have covered, the total cost of the transition, including legal administrative fees, the cost of moving into a new urban micro-apartment, and the revaluation of Taylor's hybrid work equipment, has resulted in nearly $45,000 of high-interest debt. In a traditional 2010 economy, Taylor would have been burdened by this debt for a decade, likely suffering a significant drop in workplace productivity as a result. But in 2026, Taylor is approached by a firm specializing in domestic data acquisition. The offer is clinical. In exchange for a full, unredacted transcript and all physiological metadata from Taylor's mediation sessions, the firm will settle the debt in full. The step-by-step process of this harvesting is a masterpiece of modern data science. The acquiring firm is not interested in Taylor's secrets or the specific reasons the marriage ended. Instead, they are looking for what is called the conflict signature. This involves the analysis of over 400 distinct data points collected during the mediation. They analyze the latency between digital messages, measuring whether Taylor waited 6 hours or 6 minutes to respond to a proposal regarding child custody schedules. They perform a deep analysis of lexical density, tracking whether Taylor used complex, collaborative language or short, aggressive bursts of communication. Most importantly, they harvest the biometric data from Taylor's company-issued smartwatch recorded during the mediation sessions. This allows them to correlate specific legal topics with heart rate variability and cortisol spikes. This is the new gold standard of information: emotional metadata. Why is this data so valuable to the U.S. economy in 2026? We are currently in the midst of a global race for advanced negotiation AI. Companies that develop automated customer service agents, corporate legal assistants, and diplomatic simulation tools require real-world, high-stakes conflict data to train their models. Synthetic data created by computers lacks the nuance and irrationality of a human being whose house and family are on the line. Taylor's 30 hours of mediation represent a masterclass in human negotiation under pressure. Historical case studies from 2025 show that a single high-quality mediation transcript can be used to refine the negotiation algorithms of thousands of AI agents. The potential outcomes for the data firm are immense, making $45,000 a relatively small investment for Taylor's domestic trauma. This marketplace has deep tendrils in the professional workforce. By 2026, nearly 30% of large U.S. employers have integrated data harvesting options into their corporate wellness and benefit programs. If an employee like Taylor agrees to share their anonymized conflict metadata with the company's preferred research partner, they receive immediate and substantial reductions in their healthcare premiums. The logic used by insurance companies is rooted in 5 years of statistical history. A worker who demonstrates high levels of unresolved conflict during a divorce is at a statistically higher risk for cardiovascular disease, chronic stress-related illnesses, and workplace burnout within the following 60 months. By accessing this data, the insurer can move Taylor into a specialized preventative health track, potentially saving the employer and the insurance pool thousands of dollars in future claims. However, this monetization leads to the rise of the social stability score, a shadow metric that recruitment algorithms now use to filter the American workforce. When Taylor sells that data, it does not simply vanish into an AI training set. It becomes part of a permanent digital record that classifies Taylor as either a high-stability negotiator or a high-volatility risk. Statistical data from 2026 indicates that workers who have high conflict intensity scores on the open market are 22% less likely to be considered for high-level leadership roles. They are perceived by the algorithms as individuals who might be prone to escalating internal corporate disputes rather than resolving them. Conversely, those who demonstrate what is called a mediated resolution signature, a pattern of calm, evidence-based concessions, are prioritized for roles that require high levels of emotional intelligence and stakeholder management. The dark side of this monetization is the emergence of predatory algorithmic targeting. Case studies from early 2026 have identified instances where workers who opted into these data-sharing programs were immediately targeted by specialized, highly aggressive marketing campaigns. If the metadata indicated that a worker was financially vulnerable or emotionally exhausted during their mediation, they were served ads for high-interest debt consolidation loans or questionable career pivoting services. The U.S. workforce is essentially creating a map of their own emotional and financial vulnerabilities and handing it to the highest bidder. This is the true nature of the data for debt trap. Taylor solves a short-term financial crisis by selling the very data that allows future predators to find the cracks in their professional armor. This brings us to the erosion of human empathy in the 2026 professional sphere. When every domestic interaction is a marketable asset, the way we relate to our colleagues undergoes a fundamental change. In the 1990s, a colleague might offer a sympathetic ear and a coffee during a difficult divorce. In 2026, that same colleague might wonder if you are monetizing your situation or if your stability score is about to drop, affecting the team's overall risk rating. We are seeing a historical trend where the American workplace is becoming significantly more efficient, but increasingly less human. The statistical history of mediation has moved from being a tool of personal liberation in the 1970s to a tool of corporate commodification in the mid-2020s. As we conclude this part of our deep dive investigation, we must look at the aggregate numbers. The divorce data marketplace is estimated to be worth over $12 billion in 2026. This is no longer a niche trend. It is a fundamental pillar of the modern American economy. The U.S. workforce is now a source of two distinct types of labor: the professional tasks they perform at their desks and the personal emotional data they generate in their private lives. Both are now considered essential for the growth of the national GDP. But there is one final staggering piece to this puzzle. We have seen the history, the technology, the privacy battles, and the monetization of our domestic lives. Now we must look at the endgame. What happens to the very concept of the American family and the U.S. worker when our lives are entirely governed by these metrics? We are entering the era of the post-marriage economy, where domestic partnerships are being redesigned as temporary, corporate-style joint ventures with predefined exit strategies built into the employment contract. How are the youngest members of the U.S. workforce, Generation Alpha, approaching the concepts of commitment and career after growing up in this data-saturated environment? We are seeing the first statistics on the beta test marriage, a legal structure designed to last only 3 years with a pre-mediated, automated exit strategy already in place. In the final part of our masterclass, we will synthesize 50 years of data to reveal the future of the American worker. We will look at the ultimate potential outcomes of this statistical journey and answer the question: is the mediation of our lives actually making us more productive, or are we just becoming better-oiled cogs in a machine that has forgotten how to value the human heart? The final numbers are coming in, and they will change the way you look at your career and your home forever. To truly grasp the final stage of this evolution, we must look at the emerging 2026 phenomenon known as the domestic joint venture. We are no longer living in a society where the termination of a marriage is viewed as a singular, catastrophic event. Instead, the historical trends of the last 50 years have culminated in a workforce that treats domestic partnerships as modular, time-bound projects. This is the era of the beta test marriage. Imagine a couple in Austin, Texas, in 2026 named Chloe and James. Chloe is a senior data architect and James is a consultant for renewable energy grids. When they married in 2023, they did not sign a traditional open-ended marriage license. Instead, they opted for a 3-year domestic term contract with an integrated, automated mediation clause. In this 2026 model, the end of the 3-year term acts as a natural decision point. If the contract is not actively renewed by both parties, a pre-programmed mediation sequence is triggered. For Chloe and James, this is not a moment of crisis but a scheduled administrative event. The historical data from the mid-2020s suggests that this approach has radically altered the productivity profile of the U.S. workforce. Because the exit parameters, including the division of their crypto portfolios, the shared ownership of their autonomous vehicle, and the schedule for their co-parenting of a high-end robotic domestic assistant, were mediated and coded into a smart contract at the beginning of the relationship, the emotional and professional drain is almost zero. There are no surprise legal fees, no hidden assets, and no weeks of workplace distraction. The statistical history of this shift is documented in the 2026 U.S. Department of Commerce report on domestic asset fluidity. The report highlights that the average time spent on domestic dispute resolution has dropped from 18 months in the 1990s to just 72 hours of algorithmic processing today. For the American employer, this is the ultimate potential outcome. It means that the $150 billion in annual productivity losses once attributed to divorce have been nearly eliminated in the sectors that have adopted these mediated models. We are seeing a new baseline of worker stability where personal life is as predictable and manageable as a software update. However, we must analyze the deep-seated changes in the psyche of the American professional. Generation Alpha, the first cohort to enter the workforce in this fully mediated environment, views conflict resolution as a technical skill rather than an emotional burden. Case studies from 2026 recruitment drives show that Gen Alpha candidates are actually more comfortable with automated mediation than they are with human-led HR interventions. They have been raised in mediated homes where parents resolved issues through data sharing and collaborative apps, rather than verbal confrontation. This has created a workforce with incredibly high technical efficiency, but a measurable decline in what historians call traditional interpersonal resilience. Let us look at the granular statistics of the 2026 Stability Index. For the first time, we can track the correlation between a worker's domestic contract renewals and their long-term career trajectory. Data shows that professionals who successfully navigate 2 or more mediated contract cycles without entering the public court system are 40% more likely to be promoted to executive leadership. They are seen as the ultimate collaborators. They have mastered the art of the clean exit and the fair negotiation. In the high-stakes U.S. corporate world, this ability to de-escalate and resolve personal complexity is now considered the most valuable soft skill an employee can possess. But there is a secondary potential outcome that we cannot ignore: the rise of the post-work domesticity. As the line between the boardroom and the bedroom has completely blurred, some workers are choosing to opt out of the stability score system entirely. They are forming what are known as unindexed partnerships, relationships that take place entirely off-grid, away from the data scrapers and the recruitment algorithms. While these workers represent only 5% of the professional class in 2026, their existence highlights the tension at the heart of our statistical history. They are the human heart's rebellion against the machine of the productivity-focused mediation model. Step by step, we have traced how the U.S. workforce moved from the high-conflict courtrooms of 1970 to the algorithmic conference rooms of 2026. We saw how mediation was first a legal alternative, then a corporate tool, then a digital necessity, and finally a marketable data commodity. The history of mediation is, in fact, the history of how the American worker became a more efficient, more predictable, and more transparent asset. We have optimized our most personal relationships to ensure that the engine of the national economy never skips a beat. In this masterclass, we have analyzed the staggering numbers: the 300% growth in virtual mediation, the $12 billion market for divorce metadata, and the 60% increase in workplace performance for those who choose collaborative paths. These statistics tell a story of incredible progress and efficiency. We have removed the friction that once destroyed careers and depleted retirement funds. We have created a system where the transition from one life stage to the next is as smooth as a financial transaction. Yet, as we look at the final data point of 2026, we see a lingering anomaly. Despite the near-perfect efficiency of our mediation models, the self-reported life satisfaction scores of the U.S. workforce have remained stagnant for over a decade. We are more productive, we are more stable, and our legal disputes are resolved in record time. But the human element, the messy, unpredictable, and often irrational nature of love and loss, has been largely engineered out of the professional equation. This is the paradox of our statistical history. We have solved the problem of divorce, but in doing so, we may have redefined what it means to be a person in the workforce. The story does not end here. As we look toward 2030, the data suggests we are on the verge of the transhumanist era of mediation, where biosyncing and neural-linked data will allow for domestic settlements to be reached before a person even realizes they are unhappy. We are moving toward a world where the conflict is resolved before it even begins. For the U.S. workforce, this represents the ultimate frontier of management. It is a world of total domestic harmony, enforced by the most sophisticated algorithms ever created. But as we conclude this 10-part deep dive, you have to ask yourself a question that the data cannot answer. In our 50-year quest to eliminate the cost of conflict, have we also eliminated the growth that comes from it? Are we better workers because we mediate, or have we simply forgotten how to stay and fight for something that cannot be quantified on a spreadsheet? The numbers are clear, the history is documented, and the future is already being coded. You now have the full statistical map of how we got here. The next time you look at your employment contract or your domestic partnership, remember that you are a part of this massive, ongoing experiment in human capital management. You are a data point in a 50-year trajectory toward total stability. What you do with that information will determine your career, your finances, and your future in the American workforce. But the most important data point of all is the one you haven't shared yet. What happens when the machine finally learns to mediate the one thing it can't understand? The silence that follows a perfectly resolved settlement. We are preparing a brand new investigation into the 2027 labor market, and it involves a secret movement of high-level executives who are intentionally tanking their stability scores to regain their privacy. You won't believe the numbers behind the Great Disconnect and how the most powerful people in the world are trying to break the very system they built. The loop is closing, but a new one is just beginning. Stay tuned for our next deep dive into the hidden economy of the unrated life. This was part 10. The full history is now in your hands. Use it wisely.